Okay, good morning, everybody. The paper, I think, has been posted on the website, so I'm not going to repeat what I've written. If you like to have a look, you're welcome, and comments are most welcome. Rather, I'm going to summarize the main findings and maybe to throw some topics that might be interesting, especially for me. I hope they will be interesting for you as well. I'm a libertarian, so I admit my guilt right from the start. And the basic principle is my enemies' enemies are my friends. So when I go through, say, the law and economics version presented and suggested by Chicago, and I compare it with the law and economic version proposed by Calabresi, I have no doubts on which side I want to stand, and that is Calabresi's, of course. I don't like neoclassical views. I don't like that kind of engineering approach to economics. And although I'm not 100% in agreement with Calabresi 1961, I think that that contribution, which is the contribution upon which I'm focusing, is much more interesting, thought-provoking, and open to, say, launch a debate in the social sciences. And it's actually a debate that has not been concluded so far. I mean, the kind of agenda opened in 1961, in my view, is much more fruitful, open, and thought-provoking than the one, say, launched by Coase and defined to extreme by Posner and the whole of the Chicago school. So let me start from the beginning, say why I think Calabresi 961 is important to free market thinking, where the free market story differs from Calabresi 1961, and perhaps where do we go from here. Now, the thing that I think are important to emphasize in Calabresi's approach as opposed to Chicago, and by Chicago I mean mainly Coase and Posner, is that he is very cautious, Calabresi is very cautious about efficiency and about tempering with property rights and introducing policy making for the purpose of wealth creation. My understanding is that my understanding of Calabresi 1961 is that property rights should be respected in most cases, and tampering with them is the exception. Chicago takes a different view, building on reciprocity. By and large, I'm putting it a bit extreme. I mean, Coase was not really explicit about it. Posner was and is. The judge should decide what is better for social welfare, for wealth creation, for the policymakers' preferences, and you name it, and it just moves around with the allocation of property right. Calabresi, that's my reading, is much more cautious and basically says property rights are a social arrangement, but there is a long tradition that says we have to be very prudent when we tamper with them. Reciprocity should be admitted only when property rights are ambiguous, are uncertain, and we don't really know what to do. Then the judge should come in and clarify matters. But my understanding is the judge should not come in and decide what his efficiency principle is. Rather, it has the function of clarifying ambiguities. Simplicity is one of the driving elements, and reduction of uncertainty is another one. Possibly social welfare, but once again, and I go back to the 61 article, social welfare is introduced as a criterion, but is not really developed in the in operational guidelines. Where does uncertainty come in? Well, before we go to the uncertainty story, let's go to the notion of uncertain cost. I define uncertain cost under 3 headings. Basically, we have known costs that might be uncertain, but we know the probability of distribution of those costs. So it's like, let's call them risky costs in a way. Then you have known costs. The typical example of the risky cost is car insurance. I know that my car can be stolen. I know the event, theft. And if I ask an insurance company and I tell them I have a garage, I drive around in Turin rather than Naples, and the insurance company is going to tell me, okay, the chance that your car gets stolen is, say, 5% over the next 6 months, something like that. You have other known events, like an earthquake, for instance, but in these cases you do not know the probability distribution. People know that that might happen, but if you ask an earthquake expert about it, just like an economist, it can tell you something bad might happen in the future, but they can never tell you when that's going to happen. But they can tell you, I had told you that in the past. The third category is defined by accident. Now, accident is something that might happen to you, but you do not know it might happen to you. In my paper, I give the example of asbestos 50 years ago. You might, build a house with asbestos. 50 years ago, people did not know they were harmful to your health. Then 50 years later, it turns out they are harmful. Well, that is what I call an accident, in that 50 years ago you didn't know it, now you know it. These are unknown events, which is very difficult to insure. At most, you can insure them as residuals. That is, you can go to an insurance company and say, well, whatever happens to me, you pay. Some insurers can provide insurance. Other insurers can be risk-averse. We spoke about risk aversion yesterday, and they say, no, you take the risk, your problem. I don't act as a residual insurer. Well, the free market idea, in the light of this, is very simple. It emphasizes individual responsibility. Therefore, if you are the owner, you are liable, whatever happens to you. That is, if you are the owner and something happens to you, you pay the cost. Don't blame anybody else. In particular, and I come to the social responsibility story, if you have bad luck, by definition, it's bad luck. The fact that you have had bad luck does not give you the right to put your hands in somebody else's pockets. This is kind of the coarse version of the libertarian vision, of course. You can think otherwise. I mean, if somebody else says, I'm charitable, I pity you, you've been hit by, say, a very distressful disease, I'm going to help you. That's fine. But the fact that you've had bad luck, that is, an asteroid hit your car, does not mean that the community has an obligation to make up for your bad luck. I think that Calabresi has a different opinion about that, maybe not about asteroids, but there are possibly cases in which there is some notion of social responsibility, or better, of social, say, collective solidarity. If I may say so, what is missing in Calabresi 61, and it's an open and it's a huge subject, is where do you draw the line? That is, A, where do you draw the line? B, what are the moral foundations for collective responsibility and social solidarity, in a way? And of course, you have the different visions. Starting from Hobbes and probably earlier on, you can go from the notion of the social contract. You can have sense more recently about capabilities. The idea is that economists, and we have to eat humble pie, have very little to say about social responsibility and where you draw the line and what are the criteria that help you drawing the line. This is where we're missing. And the missing piece is that we're not open enough, say, to political philosophy or to moral philosophy. We cannot sort out a social problem if we behave like engineers. And this is my, say, attack to Chicago-style people. You cannot just sit down and carry out cost-benefit analysis with some kind of brutal utilitarianism. And I believe that although Calabrese 61 does not really address the political philosophical problem, he opens up the agenda. And it is an agenda that regretfully economists have forgotten about. I mean, if you read the top 10 journals, you'll see a lot of number crunching, you see a lot of modeling, but you see nothing about where you draw the line. You see social welfare functions all over the place, but nobody really tells you what social welfare is. Calabrese is helpful in pointing out the open problem. I think that free market supporters do the same, although we come to different conclusions. But what is important is that the issue should be on the table. The Chicago guys just pretend the issue is not there. And I think that is the major flaw in the Posnerian approach. And this is why I feel sympathetic to Calabrese's approach, although we don't necessarily come to the same conclusions. Although when it comes to, for instance, respondeat superiors and liability, the two approaches come very close. That is, as I said before, the libertarian, the free market view would suggest that owners are liable because if something happens to me, it's my stuff. If I am engaged in a transaction and I'm the seller, as long as the object or the service performed belongs to me, I'm the aggressor, the offender, and the buyer is the injured party. When ownership, the transfer of ownership has been completed, then the buyer becomes the owner and liability falls upon the buyer. End of the story. That is, it is very simple. It's very simple. I'm not saying it's very clear. That is, drawing the line may not be totally unambiguous. For instance, what happens, we're talking with you last night, what happens when you have fraudulent transactions? That, of course, cheating and even the free market view believes that cheating is wrong and that cheating is a violation of the freedom from coercion principle, and therefore, even if the transaction has been completed, if the transaction is completed with a fraudulent basis, the transaction is not valid because it is equivalent to physical aggression. It is, in this case, the seller has persuaded the buyer to carry out a transaction that otherwise he would have not accepted. Of course, this opens some kind of a Pandora box. That is, where do you draw the line between fraudulent and, say, transparent or grayish transmission of information? But that's, I would say, I don't want to be, say, ask you for giving me the easy way out, but that is for the judge to decide. I mean, fraud is a matter of judges' evaluation. So in a way, under respondeat superior, the problem in the free market context vanishes. For instance, the principal in particular, the principal is always liable because it is the principal that has signed the contract with the buyer. The buyer does not buy services and or goods from the agent. It buys them from the principal. If something happens, that is, if the agent misbehaves, the principal is liable towards the buyer because the principal is the owner, because the principal has signed the contract. The only exception where the agent cannot go scot-free is when the agent colludes with the buyer. The example is I know that I'm selling you a car, and the car is faulty. I know that it's going to break down tomorrow morning. You buy it, and you buy it through my intermediary. And my intermediary also knows, my guy knows that the car is going to break down tomorrow morning. And the guy, my intermediary, is selling it to you all the same. So we're really ganging up. So we're accomplices. In this case, the agent is equally guilty. But if the agent sells the car on my behalf and he does not know that I'm giving the buyer a lemon, in that case the agent has no responsibility whatsoever. I mean, the contract is between principal and buyer. And once again, there is no problem. The problem is ownership. You just have to assess who the owner is at a given moment. So the respondent superior literature, I don't want to trash tons and tons and volumes, but to a large extent, I believe, is simplified. This is also the conclusion. It's not a matter just of ownership, it's more complex. It's also the conclusion to which Calabresi 61 arrives. The difference being that, say, the free market view would argue in favor of a Lockean-Rothbardian principle. Calabresi would argue in terms of, let's clarify the ambiguity about property rights and responsibility. So, say, the libertarian view has a much stronger view on who is responsible. Calabresi is more nuanced, and therefore he needs a criterion to clarify. And the criterion he uses in this case is simplicity, efficiency, or some kind of, I would say, deep pocket argument. He never mentioned deep pockets, I must be honest, and I'm perhaps being too extremes. But the idea is that you have some kind of an implicit contract in that I would never engage in business with somebody who is not able to foot the bill should he break his word. And the presumption is that the seller is the one with the deep pockets. In some cases, this is a bit extreme. I think it's not warranted. But if you need, say, Epstein-like simple rules, you don't have to decide. There are not many people in town. Either it's the buyer or it's the seller. And the presumption is that the seller has deeper pockets than the buyer. If that's not the case, let people exchange, let people bargain, and Calabresi 61 is, I think, happy with that. I mean, it has nothing to argue when the two parties, the buyer and the seller, principal or the agent, whatever, they contractually agree on liability. So freedom of contract and voluntary agreements, which are the bulwark of free market economics, are respected also in Calabresi 61. So to conclude, where is the basic difference between Calabresi 61 and the free market view? Well, actually, you have two differences. That's my view. And I repeat what I said some 15 minutes ago. The first difference is, can you blame or can you hold society responsible when you're a victim and you cannot find an offender? The free market view would say you cannot ask for compensation unless you find an offender. I'm very sorry if you're a victim, but you cannot, as a victim, go to society and say, I'm sorry, I didn't find the offender, you foot the bill. Calabresi is more open in this view and says, well, if we don't find the aggressor, society takes care. And it brings us back to the political philosophical argument. Where is the social contract? Where is the notion of social covenant? What is social responsibility in a community? What do you do if you don't like the community you're in? Do you take the Hobbesian view and you don't have a choice? Therefore, you are in the community for the very reason you are born there. Or do you take the Lockean case in which, being in a state of nature, you have the right to your preferences, to freedom from coercion, and to do whatever you like. Well, the difference is critical, because if you're Hobbesian, the only option is you have to migrate and move away. If you're Lockean, you can say, I'm not moving, I don't join this community, but this is my house, this is my stuff, and I don't have to quit. You can't tell me if you don't like it, get away. So these are, say, politically, philosophical arguments that are opened by the Calabrese contribution, and that they're still on the table. And they will be on the table forever, I suppose. The second story is that what do you do when you have, say, accidents? Once again, the free market view would say, you do nothing. Calabrese would say, let's have a default rule to assign liability. And once again, this is debatable. But the other thing, and so it's actually 2.5 differences, the other thing is that Calabrese, when you have ambiguity, goes for efficiency. And it looks at some neoclassical visions like the resource allocation principle, like cost minimization, to have a default rule. The free market view would go more for moral principles. So the free market view does not emphasize as guiding principle wealth enhancing, wealth creation. It does not emphasize efficiency. It might be that free market arrangements do create wealth, but that's not the point. The point from the free market view is freedom from coercion. And that is the principle around which, say, the free market supporter would build his walls and would defend his position. I stop here, and I thank you for your patience. Thank you.
So, this very interesting paper raises any number of issues. First, if I were speaking in the United States, I think I would begin by saying, be careful. What Enrico means by free market is not what most people in the United States talk about free market. That is, when people in America talk free market, they are much closer to a Chicago economic way of speaking and would describe what Enrico is talking about as Lockean property rights or a classic view of property. And I think that one has to get that on the table, because otherwise people can be confused as to what is being said. A second point, and a trivial one, is that when Enrico says a judge might decide this or a judge might decide that, that is a fair description and criticism of the early writings of mine and of others, because they were designed talking about an area of common law development where judges were the decision makers. And it was a reason why it was so difficult for this approach to be accepted in Europe, where judges didn't have that power. And so many people in Europe said originally, way back then, why are you saying this to judges when judges are not allowed to do this? And of course the answer that we gave is, we're talking about the role of judges in the United States. If you're talking about Europe, view this as being addressed to legislators or other people who do have the power to make these changes. So again, from a purely verbal point of view, these are not serious issues, but are matters of clarification. More important is the fundamental question of whether the structure of society is one that is basically designed in the first instance to achieve certain economic goals, which might be efficiency, might be spreading, which I think can be turned into efficiency, might even be distribution, it can be that, or whether one is these are all right so long as they don't violate certain fundamental rights to property, to ownership, to freedom of contract, and matters of that sort. And it's that Enrico addresses. Now, let me look at some of the things that he talks about from a purely economic point of view now, as if that were the only thing that is going on. In Respondeat Superior, there are many similarities. The only question would be the question of whether you have both the agent and the principal be liable, and you have the a liability which goes beyond the immediacy when somebody else has taken control, because there may be, the economist might say, a cheaper avoider, and so that the principal may be cheaper than the victim, but the agent may be cheaper than the principal, and so you might have them both be liable, which is in fact what happens in property in Respondeat Superior in American law. People sue, the victim sues the principal because usually the principal can pay, and then the principal and the agent may or may not go after each other. There are some instances in which the suit was against the agent simply because the agent was wealthier. When the New Haven Railroad was in bankruptcy, many people sued who were injured by rail accidents, sued the engineer who drove the train, because one of the reasons that the railroad was in bankruptcy was that the engineers were so well paid, and so you could recover more quickly against them than against the railroad, and then they would settle it among themselves. More interesting to me from a purely economic point of view is to look at two situations. One, the one in which there is no one who seemingly can do anything about an accident. The situation where an accident occurs and one doesn't see, in a products situation, where at the moment there is no alternative product that is safer. Does one leave the loss on the victim from a purely economic, I'm not talking now about the Lockean point of view, or does one put it on the producer? An argument for putting it on the producer from a purely economic point of view is that entrepreneurs, and the producer typically is the entrepreneur, are people who in a capitalist society, I would say free market society, but in the American use, not in Colombatto's use of it, are the ones who win if they take risks that others can't handle and do it right, and lose if they don't. So that to the extent that you might say the manufacturer in that situation is the entrepreneur, and if through instinct, through any of the things that cause us to pay the great entrepreneur so well, and we should, that person makes a product that is safer, while the one who doesn't have that instinct makes a product that is less safe, let the one who makes it less safe go bankrupt, and let the one who makes it more safe make much more money, and that creates an incentive for, among these risk-prone people, because that's what entrepreneurs ought to be, the ones to take risk as against the injured party who is not usually in a position, the person who is the entrepreneur. So that would be an argument from a purely economic point of view for putting the loss in a product situation on a manufacturer where neither side can do anything. That's going beyond current law. It's going beyond much current thought. But if you played it in a straight economic way, that would be a perfectly Frank H. Knight return profit for taking uninsurable risk approach. Finally, the question of limited liability, which is addressed in the paper, not so much in the discussion here. I sometimes have amused myself by looking, from an economic point of view, at the whole of the structure of an enterprise system in a country like the United States as a very complex system of no-fault liability, in which we very rarely say, you must get a certificate that this is worthwhile of regulation to enter. You enter the market, you make shoes, or you make a different kind of shoe, and if it works, you make lots of money, and if it doesn't work, you go broke. And we don't ask whether at the time you entered the market, a reasonable person would have entered the market and say, you only bear the loss if a reasonable person would not, and you don't bear the loss if a reasonable person would have. It is, we don't have a fault system. We have simply said the person who enters is the best decision maker, and in a non-fault sense, we make them liable. Why then do we have limited liability? Because the best decision maker in this sense, at a certain point, is no longer the person who enters the market. It is at a certain point the lender, the creditor, the bank, even the buyer, who says, this person is doing something that I know now ought not to be done. They are the whistleblowers. So we limit the liability to put an incentive on people to say, okay, we now know better than you that making shoes is not a good idea. Well, this isn't a place for working it all out, but one can structure, one can look at a system of free enterprise capitalism as, with limited liability, as a very interesting form of non-fault liability on the best decision maker, cheapest cost avoider, as a kind of Calabresian tort system run wild. Okay, that is one way of looking at all of this. The question that Colombatto raises with respect to each of these is that what the society wants? And then he raises it in a broader way and says, and is it what the society wants in relation to something which is not justified in classical economics, but which other people push, that is, having the losses be borne by the wealthiest, or having the losses be spread through social insurance? All of these are different possibilities which can be talked about and ought to be talked about. Now, the interesting thing is that one can talk about these in economic terms too, because one can use utilitarian economic language anywhere. One can say, what are the costs of giving up a Lockean system, or what are the costs of putting liability limitations on freedom of contract or not? Or one can talk about it in terms of rights language, and one can do it then in terms of absolute right language. This is so, and it cannot be deviated from because it is so. God himself, Aquinas, Maimonides, I don't care who, told us this way. Or one can talk about it in the way most modern philosophers now do, which is, yes, these are rights, but rights contingent on other rights and other things and so on. Now, what is the best way of talking? One could even say, what is the most efficient way of talking in order to describe these changes? When is it most, when do we explain matters best? by using utilitarian economic language, when instead do we talk best by using a language of another sort to say this is very different and we must understand what we are doing in a different way. And it's that which is, to me, the essence of what Enrico raises. When is one language of speaking better than another? I've often thought, I never wrote it and I never will, but on this issue, I've often thought that in some ways it's like currency exchanges. There are some things which are in the same currency and we make trade-offs directly. We're in the Eurozone and we buy and sell and trade things. There are some things where we do not want the trade-offs to be quite so easy, and so you have to go and buy another currency. Change the language, change the currency, but then you can make the exchange. You have to make an additional step. There are some things where we want the trade-off to be made, or the limitations on rights, if you want, to be yet more difficult, and you have to go and get permission to do it in terms of currency. And then it's very hard to say we give up the fundamental right. And there are some things where we say you may not do it at all, no trade-offs are allowed, but we know perfectly well that they are. That is, that even the most absolute of rights in complicated situations do yield, although we like to speak of them as being absolute and things that we don't. The question that never gets asked in much economic analysis, and that is what Enrico, I think, focuses on, is when do we want to do this? Now, there will be some people who say, I don't start with his point of view at all. I have a different point of view. It's not a free market or whatever. But they will have their equivalent set of rights and say, when do we deviate from them? That's a different issue. But from this point of view, I think one can look at all of this from an economic point of view and then say, what does it cost? No. What are the rights we must deviate from? Or can we deviate from those rights? And that, I think, is what is the thing that Enrico's paper makes us think about. I've talked too long, but it was the paper that made me do it.
Thank you.
Are there other questions or remarks? Yes, Giovanni.
Long-lasting question started yesterday at lunch. Anyway, I remember Pliny the Elder was writing actually, do not buy slaves coming from asbestos mine because they die young. So thinking about your third example, the problem is that theoretically I can understand, but then when I figure out, it seems to me that all the examples are collapsing in one. So that, I mean, and I see that your division is more focusing on some distributive principle rather than the accident per se, in the sense that you think that in some cases there are responsibilities, in others there are no. So in this case, you shouldn't apply the theory. But if you look at the same story from a different perspective, it's just like extending the market in the liability system. I always saw the liability system, possibly I'm wrong, is an extension of the market. Whenever the market that you know does not work for any reason, court is another market in which you can claim your liberties. So in this perspective, it's not violating the market. It's just that market can be incomplete, exchange can be incomplete for many reasons. I mean, the contracts are incomplete. And so this is a way for enforcing rather than weakening the individual freedoms.
Yeah. May I say one other thing? Because Enrico said some things about social contract, and then and cited Buchanan and Tulloch. And I can't resist telling the story of when Buchanan, who is one of the great, great scholars of all time, came to Yale and gave a talk in which he was decrying all of the things that the Warren Court was doing, had done, as violations of the social contract. And the social contract to him was the Constitution as he read it in very literal terms, and he was saying that Warren had done this and Warren had done that and Warren Court had done the other. And I couldn't resist raising my hand and saying, you know, I like this idea of the social contract in some way. My problem is I don't really know what the social contract was. I'm perfectly willing to assume a situation in which all these original social contractors were there, and very wealthy and very articulate people start putting into the social contract all the things that you, Buchanan, say are there. And they put in one thing and another thing and another thing and another thing, and the social contract starts to look very much like the way that you have it. And then a very small, rather poor person in the back gets up and says, okay, I'll agree to that social contract, but only on one condition, that once every 200 or 300 years, the social contract gets interpreted by Earl Warren. And that gets put into the social contract, and that's as likely to be in that social contract as everything that you've put in there, Jim. Well, he looked at me, first very angry, and then burst out laughing because he is such a wonderful scholar, and he understood what I was saying about social contracts.
Yes, on social contracts, then I come to you. I fully agree. I don't like this social contract idea because today's social contract is really an elegant way of saying that you are right and the others are wrong simply because they have a different vision of your social contract. So, and I must say that we have to be honest towards Tulloch. Tulloch never bought it. It's really Buchanan's invention. Tulloch is always very wary of the social contract idea. The problem with the social contract, and that would be another Pandora box, brings you back to the notion of natural rights. Because in the end, you have to say, well, what is not open to discussion? What is immanent in the individual as a human being? Those are the only, say, things that we can take as implicit, that do not need explicit agreement. And it's not by chance that Locke said that in order to get out of the state of nature and go into society, you need explicit consent. So the social contract is an explicit agreement. It can never be implicit, as, say, the tradition or long tradition that came after John Locke said. Then I would also like to take on John Locke, but it will be for another conference, perhaps. Much to my regret, I agree with you. The story is that I'm not saying that there are no ambiguous situations. And I'm not saying that when you reach a deadlock, you must have a social arrangement, say, we have a deal, and if we decide that if we have a discussion, we have to go to somebody else to say who's right, who's wrong. My point is to say, let us not call uncertainty or ambiguity something which is not uncertain and which is not ambiguous. So we have to draw the line regarding where are the ambiguities. When it comes to, say, accidents, my view is there is no ambiguity about who the owner is and who the rest of the community is. When it comes to asbestos, I have no doubts that 50, 60, 70 years ago, nobody knew that they were harmful. But I might be wrong. As you say, Plinius had a different idea, but if you ask, say, people 60 years ago, you said asbestos, that's fine. What's the problem? But I would agree with you that if I'm wrong, and if you can tell me, as you can tell me today, that everybody knows, or a large majority of people know that asbestos are dangerous, and I give you asbestos, and I don't tell you that there is asbestos in the building, that's fraud. And, the case is clear. So we can talk about drawing the line between fraud and absence of fraud. But that is, the line is fraud. It's not social responsibility. But I know that we have different opinions.
Okay, thank you. So I think that we should move to the next presentation because it's we have spent time on this, even if it's interesting, and even if I'm tempted to say a few words to defend the idea of social contract. But we have to move to the presentation by Steve.